record of the United States Supreme Court is marred by its performance in the last part of the 19th century. Writing from the vantage point just after World War II, Henry Steele Commager said he thought the Supreme Court had been a drag on good government, that the examples of the Supreme Court upholding liberties, defending the rights of minorities was basically non-existent. There are very few cases one could think of that tended to make the 14th Amendment what it was intended to be. You find lots of cases where the 14th Amendment was turned into an instrument of protecting property and corporations. To give you just a brief example that I'll talk about in another lecture, due process of law was not about representation by counsel or trial by jury. It was trying to prevent governmental regulation of businesses and employers, and making sure that they were free to do what they wanted to do, which of course has nothing to do with the historical concept of due process. The problem begins early. There's a case in 1873 called the Slaughterhouse Cases. This is a United States Supreme Court decision brought to the court by one of its former members. Associate Justice John Campbell resigned from the Supreme Court to become a minister of the Confederate government. He had signed the Dred Scott decision. He was one of the ministers who met with President Lincoln, one of the peace commissioners just before the war. He was a interesting personality. And he's up before the Supreme Court representing disgruntled butchers who did not want to live with Louisiana regulation, which said if they wanted to do their business, they had to work with a Louisiana-created monopoly to make sure slaughterhouses were not within the municipal limits of New Orleans. Now, everybody can understand why the process of butchering animals might need to be just a little far away from the city of Louisiana. But there was former Justice Campbell saying this is one of the basic rights of man, the right to work, the right to be free of monopolies. He was making an argument that bore no resemblance whatsoever to anything that was discussed in Congress or the states when the 14th Amendment passed, but it was filled with passion, history, literature, oratory, and he came within one vote of bringing it about. Justice Campbell's strength as an advocate was on display, but the result was a decision which basically said the issue of what is liberty, what are the civil liberties protected by the Constitution, is not a national responsibility. The court upheld the earlier principle that the basic liberties of the country, which we today all take for granted, are matters for state law. And this meant that a good deal of the progress that would be achieved in the 1960s was delayed for decades. The Supreme Court rendered the most narrow interpretation of the word liberty in Section 1 of the 14th Amendment possible. But it was not the only case. There's a case called United States v. Cruikshank in 1876. This arose from a famous race riot. And a race riot in New Orleans, but it's a case of where whites, Ku Klux Klan members and such, attacked a political meeting of black people and Republicans, and they shot them down. Just mass murder. The ringleaders were acquitted on state charges by an all-white jury in Louisiana. The United States, the national government, brought a prosecution under federal civil rights laws that had just been passed by a vigorous Congress. And the Supreme Court of the United States ruled that punishing private crime was not a proper function of the national government. It was an issue to be left to the states. Now, this wasn't the only pair of decisions being rendered. There's a third one that I didn't put in my notes. I want to mention it. Bradwell versus the United States. Someone asked me about gender discrimination. First gender discrimination case under the 14th Amendment was brought by Myra Bradwell. She was a distinguished person in Illinois who created the first law review west of the Mississippi. She took her bar exam, and as I like to tell my students, the bar exams of that period were a good deal tougher than the bar exams of today. You had to present yourself to a 3-person committee, which also included the local public prosecutor. And they could ask you any question, and you were supposed to give satisfactory oral presentations on the law to the point where they would be willing to say, you could be a lawyer. Well, she did that. Everybody respected her. She passed with flying colors. And when her petition to become a member of the bar was presented, the Illinois Supreme Court said no. The statute referred only to men, and therefore women couldn't be lawyers. Well, they basically didn't say that to Myra Bradwell. She pointed out all the ways in which the statutes refer generically to men, but they mean the whole family of man, including the most obvious one. Yes, it says, be the right of man to worship God. Well, does that mean only men? Females are not entitled to worship God? Well, then she did something that was probably not all that diplomatic. She presented this argument in her law review, published it for all of Illinois to see, and the Illinois Supreme Court then retreated, saying, well, we didn't mean what we said, blah, blah, blah. What we really meant to say is that she can't be a lawyer because she does not have the capacity to act for herself. She's a woman, and like children and incompetence, a woman cannot sign a contract and bind anybody to it, therefore she can't be a lawyer. Well, that wasn't going to sit very well with Myra Bradwell either, so she presented all of that and pointed out that it bore a strange resemblance to the U.S. Supreme Court decision in Dred Scott. Well, in the aftermath of the Civil War, these are fighting words. You do not compare a judicial opinion to the worst opinion in American history that caused the deaths of 750,000 people. Unfortunately, she presented her case to the United States Supreme Court, which upheld the Illinois Supreme Court and said that the exclusion of women from the practice of law was demanded by, I kid you not, divine natural law. Well, it took us about a century to get rid of that one. And that's one of the cases which shows this restricted, culturally biased attitude toward equality and toward liberty. The key event in all of this is not what's happening in the Supreme Court. It's something known as the Compromise of 1877, and it begins with the 1876 presidential election. Samuel Tilden wins the popular vote over Rutherford B. Hayes. However, many southern states are still controlled by the Union Army, and the southern states, including, I kid you not, Florida, return electoral majorities for the Republican Party, and the disputed election is thrown into litigation before Congress, which creates an electoral commission which contains an awful lot of United States Supreme Court justices, and they look at the issue and they arrive at what's known as the Compromise of 1877. And the result of this compromise is Tilden loses, the Democrat. The Republican Hayes wins. And the South basically tolerates this stolen election because they make some promises. And the two promises that are important to us are, one, Union troops will be withdrawn from the South, and two, the issues of race will be handed over to the South, and the North will not interfere with home rule. By 1900, the price of Republican victory, Democratic toleration of Hayes's election was exacted in full, and there's no other way to put it. It was the systematic, brutal suppression of black people. The U.S. Supreme Court, which had been part of the Electoral Commission, cooperated with this Compromise of 1877. In United States versus Harris, 1882, the Supreme Court struck down the Grant administration's 1871 anti-lynching law. It's called the Ku Klux Klan Act. It's unconstitutional. National government can't punish private crime. Lynch mobs are no business of the feds. This is the issue that's still haunting civil rights prosecution in the 1960s, when thugs murder 3 civil rights workers in the summer of 1964. That's the Mississippi burning case, if you're not familiar with it. For my money, the worst moment comes when the Civil Rights Act of 1875 comes before the court. Now, you need to understand what the Civil Rights Act of 1875 was. It was a progressive, visionary, idealistic piece of legislation signed by Ulysses Simpson Grant, President of the United States, the most popular man in America at the time, and what it said was, blacks were to enjoy equal rights to public accommodations. It was the full functional equivalent of what would later become Title I of the Civil Rights Act of 1964. What Martin Luther King was arguing about, what Lyndon Johnson and John F. Kennedy were trying to pass in 1964, had passed Congress in 1875. And it came before the United States Supreme Court in the Civil Rights Cases of 1883 and the United States Supreme Court, remembering the Compromise of 1877, struck it down. It was no business of Congress to legislate with respect to private sector discrimination. The Kennedy administration was still struggling with that Supreme Court decision when they're drafting the 1963 Civil Rights Bill. And that causes them to turn to the Commerce Clause. That, by the way, is the issue that Rand Paul was talking about when he said, discrimination by the private sector is not the business of Congress. Now, he's since retreated, largely because he got caught saying it on MSNBC, not the place to see it, but it was a flabbergasting moment to hear a prospective President of the United States and a sitting United States Senator drag that old principle out of law books. The worst case, of course, is Plessy versus Ferguson. You've all heard the phrase, separate but equal. In this case, the Supreme Court upheld Louisiana legislation that upheld undeniably separate and allegedly equal accommodations for black people. Now, I'm not going to be subtle here. I get to be subtle when I have to devote a full 50 minutes to Plessy versus Ferguson. Plessy versus Ferguson rests on a lie. The United States Supreme Court uses words admitted by later Supreme Courts to be false and known to be false when published. The primary evidence of this, the Supreme Court's own words, quote, "We consider the underlying fallacy of the plaintiff's argument against the legislation to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it." Not so. Known not to be so at the time. As a result of Plessy versus Ferguson, the South, led by the Democratic Party, fulfilled the campaign promises that they'd made and the promises that were implicit in the Compromise of 1877. This is the birth of segregation. Segregation was mandated on streetcars and waiting rooms, in hospitals and prison and housing and in cemeteries. These were new laws passed in the 1890s and the 1900s. They included segregated drinking foundations. Oklahoma proudly made its contribution in 1915, segregated telephone booths. Segregation shocked some white Southerners. One editor in South Carolina voiced his opposition. He ridiculed the policies. He wrote this: "If there must be Jim Crow laws upon the railroads, there should be Jim Crow laws on street railways, passenger boats. If there are to be Jim Crow sections of the jury box and a separate Jim Crow dock and witness stand in every court, surely there must be a separate Jim Crow Bible for every colored witness to kiss." The editor thought this policy absurd. However, historian C. Van Woodward, in his book, Strange Career of Jim Crow, documented all these improbable applications became reality, down to and including the Jim Crow Bible. As a result of the work of the Supreme Court, the 14th Amendment was betrayed. The African Americans who had fought for the Union were betrayed. And it took all too long, a century, to finally complete Mr. Lincoln's dream of a new birth of freedom. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.